Hello and good afternoon, everybody. Thank you very much for joining us today. I'm Stuart, I'm a corporate partner at Clarkslegal, and I'm joined today by James Hopkirk, who's a insolvency practitioner and restructuring director at Kreston Reeves. Thanks for joining us today, James.
Thank you.
So today we are going to present in two parts, really. We're first of all going to have a run through of the insolvency legislative changes and amendments that have been introduced since the onset of lockdown last year, and we're then going to move on to look at prepacks in light of those reforms and present our view on how we think insolvencies are likely to be dealt with for those sustainable businesses, otherwise sustainable businesses going forward. And James is going to give us the benefit of his insight and know-how on that topic. So thank you again for joining us. Before I begin, just a couple of housekeeping points, really. There's a chat function, so please feel free to ask any questions. We do like questions. We do our best to answer them. If we can't answer them in the time we've got, then we'll of course come back to you by email, and as I say, do our best to answer them. The other thing is that we'll circulate our slide deck to all those attending, so we'll let you have that as well. At the end. It is a live webinar. If there are any technical hiccups, hopefully not, but if there are, please do bear with us. So without further ado, it's certainly right, really, that we set the scene by looking at the Corporate Insolvency and Governance Act 2020. And of course, this was a piece of legislation that was rushed through the statute machine, published in May, quickly receiving royal assent and thereby becoming law on the 25th of June last year. And as many of you may know, that introduced a number of quite pivotal amendments and changes to existing law, putting in place some temporary easings of company law procedures, and introducing one or two new areas. So, breaking it down, really, there were a number of permanent measures introduced by that legislation, if you like. One was the introduction of a new moratorium designed to give further breathing space for businesses while seeking rescue, very much envisaged with the pandemic in mind. And then there was a prohibition on the automatic termination rights we see in many contracts that trigger termination of an engagement automatically on an insolvency procedure. And then, of course, there was the introduction of the new restructuring plan, which, as we know, binds classes of creditors even if they don't necessarily agree, and all designed with the view to give businesses the breathing spaces they very much needed. Number of temporary measures were also introduced, so the generally suspension of some of the antecedent provisions of the Insolvency Act 86, this prevention of winding up petitions, the introduction of the COVID test, the suspension of wrongful trading and associated personal liabilities of directors to give them breathing room to think about how they can maintain the survival of a business and the associated economic benefits that go with that. And of course, there were some extensions for the statutory filing processes at Companies House, and some provisions that were introduced to enable shareholders' meetings to be held electronically, irrespective of the fact that company articles necessarily permitted it or otherwise. So these were, as I say, all brought in quite hastily to create breathing space and minimise the damage to the economy caused by COVID. And of course, one of the things that the government couldn't foresee was just how long we were going to be subject to various degrees of lockdown and restriction, which curtailed the development of the economy and the easing of some of these measures. So we, as many of you may know or may not know, we saw this legislation extended towards the end of the year in 2020, and then we also saw it extended again. And currently, the deadlines for the prevention of winding up petitions, unless you satisfy the COVID test, as they call it, is the 30th of June, so the end of next month. The suspension of wrongful trading provisions, again, have been extended until the end of June, as has the automatic operation of termination clauses that end an engagement for services or goods on liquidation or other form of insolvency. The caveat here, of course, is that the COVID Act itself introduced broad powers, range of powers, to enable the Secretary of State to make further legislative amendment through regulation, which is how the COVID Corporate Insolvency and Governance Act have been extended not once but twice. So I make that point because it's important to note that whilst currently those are the extended deadlines, we don't know whether or not they will be extended further. The views of commentators in this field really change every day with, of course, what's happening and what's happening with the pandemic generally. So what does that mean for us? Well, you know, on the back of that, we've obviously had a depressed corporate insolvency market, which isn't necessarily negative. Sorry, James, but isn't necessarily a bad thing. We've also got this position where cheap money and a number of companies have been sort of, you know, limping along since the crash of 2010, and there's a view that there's a logjam building where once the easing of fiscal stimulus and policy comes to an end, there may well be a run on insolvency. Of course, we don't know that the end of June is the end of these temporary measures being lifted because of the regulation and the Secretary of State. And similarly, of course, we've seen changes to Crown preference brought in not by the COVID Act, but by earlier legislation, where the Crown now ranks in priority to floating charge holders and the other class of creditor that fall within the statutory entitlement. So essentially, there's a lot that's potentially going to come out of this when these measures come to an end, fiscal policy ends, extensions end, monies aren't paid back, issues with HMRC. We are foreseeing an increase, we just don't know quite when yet. What we tend to think, though, that, you know, there are a plethora of very viable businesses out there that would continue, but for this unexpected level of debt that they've had to sustain to keep them in existence and surviving. And therefore, what we don't know, and in time itself will tell, is whether we'll see a significant uptake in the new arrangement mechanics that are laid out in the Corporate Insolvency and Governance Act, or what we suspect will be an increase in classic prepack administrations who are naturally designed to support businesses that would otherwise survive but for unacceptable levels of debt. So thank you. I'm now going to hand you over to James, who's going to look at the operation of Prepacks and reforms post-COVID in a bit more detail for us. So James, over to you. Thank you.
Thanks, Stuart. You're controlling the slides, aren't you? If I just give it a next slide, please. You're happy with that?
Certainly.
Yeah. So next, first one then, please. So yeah. So thank you, Stuart. That was a really good overview. As Stuart said earlier, I'm James Hopkirk and I'm an insolvency practitioner at Kreston Reeves. I'll now focus specifically on prepacks and the administration process. Prepacks are a procedure which all use the general administration process, so let's start there. An administration is designed to protect a business while plans are formed either to put in place a financial restructuring to rescue the company or to sell the business and assets to produce a better result for creditors than in a liquidation. An administration can also be used where neither of these objectives can be achieved, simply as a mechanism to liquidate assets and distribute the proceeds to secured or preferential creditors. But this is not their primary purpose, and an administrator has a duty to seek to achieve the initial objectives unless they simply aren't practicable. Once an administrator is appointed, he takes over the running of the company from the directors and is responsible for any decision to continue or discontinue trading. And he has control over how the business and all the assets are disposed of. The ability to continue trading depends on the availability of funds for working capital, the willingness of existing suppliers and customers to deal with the company in administration, and other specific issues such as licensing rules. An alcohol premises license, for example, might automatically elapse on an insolvency event, which would clearly impact on trading. The main protection for the company comes with the automatic implementation of a moratorium, which is a different moratorium than Stuart spoke about earlier, and I'll go into that in a bit more detail in a while. But that prevents creditors from taking action to improve their position and prevents landlords from forfeiting a lease without permission from the court or the administrator. An administration is a collective process, by which I mean that it encompasses all of the company's debts, and there are rules to ensure that creditors are treated evenly compared to other creditors within the same class. An administrator has a duty to act in the best interests of creditors generally, rather than owing a duty to each individual creditor. The companies which require an administration are almost always facing severe distress, and the process for appointing an administrator can be very straightforward, allowing the directors or a charge holder the ability to appoint an administrator by filing papers in court without the need for a hearing. There are certain restrictions which I won't go into in detail, but one example is that where directors seek to make an appointment, but there is also a charge holder which could appoint an administrator, the directors are obliged to file a notice of intention to appoint, which will give a short window where the charge holder can decide to appoint somebody of their choice rather than the director's choice. So next slide, please, Stuart. So the prepack. A prepack administration is basically an administration where the administrator uses their powers to undertake a sale of the business of an insolvent company immediately upon their appointment or very shortly thereafter. There are advantages to this. For the administrator, it eliminates the need to trade the business, which can be costly due to the administrator's need to oversee the trading. Indeed, as before, trading may not even be an option if there are licensing problems or funding issues. For the purchaser, they will acquire the business from a licensed and regulated insolvency practitioner, which should offer some degree of assurance to them. And also they can transition the business seamlessly. Well, that's the idea, with a minimum of disruption to goodwill. An insolvency practitioner who has been nominated by the directors to act as administrator will work with the directors to identify a prospective purchaser, which can sometimes be the directors themselves acting via a new company. And then the insolvency practitioner will negotiate terms which are agreed in advance of the administrator's appointment. As before, the administrator will then be appointed and effect a sale immediately thereafter. The insolvency practitioner is again regulated and will be bound by a code of ethics. He or she will need to make it clear to the directors that their role will change as the process develops, and it is of fundamental importance that the administrator is able to act objectively and independently. The administrator should initially be advising the board of directors rather than the directors personally, and the administrator certainly shouldn't be providing advice to the purchaser of the business to maintain that independence. And next slide. So I'll mention later about the efforts an administrator should take to market the business for sale, because that's a big area on its own. Creditors are naturally wary of a sale to the existing management team, as there may be a perception that they contributed to the demise of the insolvent company, put simply. However, the insolvency framework is designed to recognise that there are very often external factors which cause a business to fail, and there is no inherent issue with the directors acquiring the old business and starting again. The key aim for the administrator is to ensure that the assets are sold for the greatest sum possible, and it is often the directors who will perceive there to be the most value in the business or assets, maybe simply because they may have invested a great deal of time and energy themselves in establishing the company. For some time, best practice has dictated that the insolvency practitioner should recommend to the purchaser that they may wish to seek a second opinion on the proposed deal from an entity called the prepack pool, with the idea being that the administrator can say to creditors of the insolvent company that a party who is entirely independent of the deal thought that it seemed reasonable. For various reasons, only a very limited number of opinions were sought from the prepack pool, and so this year, perceiving that to be a problem, the government has brought in new legislation with the effect that an administrator can't implement a prepack, which, according to these new rules, is strictly a sale within the first 8 weeks of their appointment. And that can't be done without the purchaser having sought the opinion on the deal of a suitable evaluator. So that only applies where the purchaser is a party connected to the insolvent business. I think it's fair to say that this new legislation hasn't been the most popular amongst insolvency practitioners, many of whom feel that it seeks to address a problem which is not, in fact, very prevalent at all. Whilst doing that, it adds a layer of cost and regulation which perhaps could reduce the sums which might be available for creditors. But whatever our views on that, the new legislation has been implemented, and my personal feeling is that it won't place any insurmountable barriers in the way of rescuing good businesses which have found themselves in distress. And next slide, please. So who might need a prepack? A simple answer is any company that has a good underlying business but which has found itself in debt for whatever reason. And with a pandemic, as Stuart said earlier, I'm sure there are plenty of businesses in that position. Unfortunately, company directors often avoid addressing these issues until a company reaches crisis point. For example, if they're not going to have enough money to pay the payroll at the end of the month, and that can sometimes be a trigger to come and talk to someone like myself. Normally, financial problems will build up over time, and we'd be encouraging directors of distressed businesses to prepare longer term forecasts, for example, so that problems can be seen coming at an early stage, which hopefully will mean the directors have options beyond the formal insolvency process. Next slide, please. So there are plenty of other options. Before I go into more detail about prepacks, let's have a think about a couple of those. And non-statutory solutions are those which have no formal basis in legislation. They can be more flexible and less expensive solution for the company's problems. However, because they're not defined in legislation, they won't be binding on all parties, and they tend to result in a higher level of risk for the company and its directors. The typical examples of those are informal agreements. The most common example being a time to pay arrangement with HMRC. Reaching a repayment plan or payment holiday with one creditor will prevent that creditor from taking action, but if there are other creditors who are applying pressure, a separate agreement might need to be reached with them. And this can very quickly become time consuming and stressful for the directors if there are lots of creditors. Another option is refinancing. A range of refinancing options will be available. Many will require some form of personal guarantee from directors and or granting of security over the company's assets. So the availability of refinancing will depend on a variety of factors like those. And then a solvent sale. If it may be possible to sell the company if there is a buyer who's willing to take on responsibilities for the outstanding liabilities, obviously depending on how much they are or how certain they are. Beyond those non-statutory solutions, you've also got some statutory solutions. I'll go into a little bit more detail about the moratorium that Stuart was mentioning earlier. It's a fairly new procedure which became available last year. And to be clear, it's separate from the moratorium in the context of an administration. And the clear focus for this one is to rescue the company as opposed to selling the business and assets, which might rescue the business. So a moratorium is designed to provide a short breathing space to protect the company from creditor action while plans are formed to rescue the company as a going concern. The plans put in place will depend on the particular circumstances of the company, but it could involve the company entering into a company voluntary arrangement. The moratorium lasts for an initial period of 20 business days, but it can be extended up to a maximum of 1 year. The moratorium procedure differs from other formal insolvency solutions in that it is what is known as a debtor in possession procedure. While under most other insolvency proceedings, an insolvency practitioner takes control of the company, in a moratorium, the directors remain in control. So the directors remain responsible for the day-to-day running of the company and for its continued trading, which includes paying suppliers and other liabilities incurred during the moratorium. And they're also, directors remain in charge of putting together the rescue plan, although obviously they'll be getting advice on that, probably from the insolvency practitioner. So an insolvency practitioner is still involved in the moratorium procedure, acting as what we call a monitor to look after the interests of the creditors. The monitor cannot advise the directors, although they could potentially act as nominee and then supervisor in respect of any CVA. The monitor has certain statutory duties, including satisfying themselves that the company is paying suppliers and others for liabilities incurred during the moratorium, and that it remains possible to rescue the company as a going concern. If that isn't the case, the monitor can take steps to bring the moratorium procedure to an end. So just briefly on CVAs, which is the other more long-standing rescue tool, that's a procedure which enables an insolvent company to reach an agreement with its creditors to delay or compromise the payment of its debts. The CVA is flexible and can be adapted to meet the needs of most businesses. In essence, the CVA will replace the terms of the company's existing contracts with its creditors with new terms as set out in the CVA proposal. For example, the proposal might require the company to pay a fixed monthly sum into the arrangement for a set number of years so that creditors can receive a minimum dividend of X pence in the pound, maybe 50p in the pound. While the payments are maintained, no further action is necessary and the directors retain control of the company. And once the arrangement is successfully concluded, the company remains in control of its existing members and management. So creditors will usually agree to support a CVA where it can be shown they will achieve a better outcome than if the company was liquidated and the business and assets were sold that way. They might also want to see changes to the management and operations of the company to ensure that similar difficulties will not arise again. The company will successfully complete the CVA. So we've seen an example recently where HMRC wouldn't support a CVA unless the entire board agreed to resign and for an interim director to be appointed for the first 6 months of the CVA just to get it up and running, which the directors agreed to. So again, not to do with company rescue really, but I'll mention the creditors voluntary liquidation. It's a process where the directors of an insolvent company can voluntarily take steps to wind up the company. So once appointed, a liquidator takes control of the company, and rather than focusing on rescuing the company or the business, it's more common for the company to cease trading and its assets are sold to repay the cost of liquidation, and then any surplus being paid to creditors. It's clearly not the focus of this talk, and the emphasis is on avoiding that and getting in early enough that we've got options to rescue the company or the business. Next slide, please. So let's go back to prepacks and think about how they actually come about. The directors will come to an insolvency practitioner normally because their accountant or solicitor has alerted them to an issue, or because creditor pressure has become intolerable. Where we're dealing with an owner-managed business, it is very common that the directors will wish to continue the business, and an insolvency practitioner will advise them of the various options, including the prepack solution. The directors will be informed that it isn't necessarily a problem for them to acquire the business and assets as long as every effort is made to obtain the best possible price. In the alternative, it's sometimes the case that the directors will be looking to partner with an investor, and they might put the insolvency practitioner in touch with that investor as a potential purchaser. Either way, the same principles apply, really. So a key obligation on the part of the insolvency practitioner relates to marketing, and there is detailed best practice guidance as to what steps need to be taken with a view to broadcasting the opportunity as widely as possible. If interested parties do come to light, then the directors must be informed of their duty to act in the best interest of the company and the creditors, and cooperate with the potential purchaser to allow them to undertake due diligence to properly understand the business and, formulate an offer. As marketing collateral, a basic and anonymous flyer might be initially prepared, which briefly describes the opportunity, and that is then distributed to potential purchasers. Fairly common that the insolvency practitioner might then set up an electronic data room, which can be accessed by interested parties who will be required to sign a non-disclosure agreement, to allow them to decide whether they want to make an offer. Once a preferred bidder is identified, then the parties can look to agree terms and work with the directors to coincide completion with the commencement of the administration. So just a sort of brief example of that. We had a restaurant business where the directors had invested heavily, in terms of finance and emotion and effort. And it was one of those situations where the company's difficulties were, an unfortunate event that you weren't going to pin any misconduct on the directors. It was really just a failed venture. And the directors maybe had an issue accepting responsibility for that, but I needed to convince them that if they wanted to do a prepack, then there'd be some marketing to do. And whilst the directors were kind of hoping there wasn't going to be any other interest, it was my job to find out if there was. So a third party with deep pockets and a chain of restaurants themselves showed an interest and wanted to make an offer. The directors felt the purchaser was exploiting an opportunity, and the directors weren't enthusiastic about assisting with the process, but ultimately that wasn't really my concern. What interested me was obtaining value for creditors. The motivation of the purchaser isn't really a big issue for me. So I needed to explain carefully to the directors the purpose of the administration and their duties. And ultimately they didn't want to do it, but the directors realised that they'd have to, find additional funding and increase their bid. So I think the point of that brief example is that, the directors might hear about a prepack from their friends who have done one and think it sounds like a great idea, but the role of the insolvency practitioner is to, temper their expectations, make sure we're acting independently. So if there is genuinely some external interest in making an offer, then we explore that fully. And ultimately in that case, it was a good outcome for the creditor. The directors still got their business, and it just cost them more. Next slide, please, Stuart. What are we up to? How to obtain best value. So, owing to the nature of distressed businesses, any marketing will normally need to be done on an accelerated basis. We've seen it done start to finish in 2 weeks, from the directors contacting us to completing a sale. The directors have sought advice usually because they've reached a crisis point, which again limits the amount of time that you've got available. The key source of best practice guidance for insolvency practitioners is called SIP 16, which is Statement of Insolvency Practice 16. And the key part of that, for the purpose of this talk, really are what it calls the marketing essentials. So first one is broadcast. Business should be marketed as widely as possible, proportionate to the nature and size of the business. The purpose of the marketing is to make the business's availability known to the widest group of potential purchasers in the time available, using whatever media or other sources likely to achieve that outcome. We'll also need to justify the marketing strategy to the creditors in a formal report. The statement to creditors won't simply be a list of what marketing has been undertaken. It should explain the reasons underpinning the marketing and media strategy used. Sort of getting the theme that people are very wary of these kind of deals and that there's a lot of explaining to be done. Independence is important. That's another one of the essentials. Where the business has been marketed by the company prior to the insolvency practitioner being instructed, this should not be used as justification in itself to avoid further marketing. The administrator needs to be satisfied as to the adequacy and independence of the marketing undertaken already. The next one says we need to publicise rather than simply publish. Marketing should be undertaken for an appropriate length of time to satisfy the administrator that the best available outcome for creditors as a whole in the circumstances has been achieved. Creditors should be informed of the reason for the length of time settled upon. So, as before, this might be a very short period of time, but there must be a clear reason for that, and we will need to explain the rationale to the creditors. They're the stakeholder that's losing out effectively, primarily. And then the final one is connectivity. So we need to include online communication alongside other media by default. I think that's a little bit out of date, that one. I think the internet is the primary way of communicating with people these days, but it does state if the business isn't marketed using the internet, then that should be justified. So again, all of this is disclosed to creditors, and the insolvency practitioners regulators also see a copy of the disclosure. Almost invariably, I'd expect the insolvency practitioner to be working alongside valuation agents with suitable expertise in the field who can reach potential interested parties and provide a professional opinion on offers received. The directors will need to be honest about parties who might be interested as well and play their part in helping us to reach them. The directors may have previously received offers from competitors, and really they should tell us about that. And the valuation agent can assist with negotiations and put in place a formal process for best and final bids, etc., where comparable offers are received. It can get quite interesting when there are similar offers received. You have to look at things like how much of the sale consideration is on a deferred basis, whether they're offering security or guarantees, whether the purchaser is taking on some employee liabilities or maybe some landlord liabilities, which improves the overall position for other creditors when we're looking at what deal to go with. Next slide, please, Stuart. Okay, so again, I just wanted to raise a sort of brief imagined scenario and just run through some issues that directors might face, which might make the process a little less seamless than hoped. If you imagine a nice big food distribution company with some very good restaurant clients, might have 150 staff or something like that, but maybe they're looking to shed certain departments of it or, reduce the sales function possibly. And imagine they had a crisis with their stock control system, which caused big issues. For a while they had no visibility on stock, which caused them to lose clients because the clients are used to getting deliveries every day, and that led to debts mounting up a little bit. And they seek advice, and they decide they want to pre-pack their business, transition the business from the existing insolvent company to a new company. And we're thinking what issues might arise. So they're supplying food to people that they're storing in a warehouse, and the first one that springs to mind is retention of title. So rumours begin to cycle around the industry because the staff see people walking around the site, and suppliers begin to become aware there's a problem. They turn up at the door and say, you've got a load of our stock there you haven't paid for, I want it back, please. And for the administrator or the insolvency practitioner who's going to be the administrator, they're keen to preserve as much of the business intact as they can. So this isn't a great idea to start letting people have their stuff back. And indeed, the moratorium being in place means that the ROT creditors can't, insist on having their stuff back. But, the directors, let's assume the directors are going to buy this business, they've got to think about reputational issues. If they're turning people away saying you're not having your stock back that we haven't paid for, then, what message does that send? And what does it do to future supply relationships with these people? Separately, the employees, again, for a brief period prior to the deal, will almost certainly know something's going on. We might need to reduce staff numbers, and consultation might be required, even if we don't have time for a full, 90-day process. That's it would be unusual for that to happen, but, there's certainly an accelerated consultation would be appropriate. The landlords can be an issue almost always, because you need to ultimately assign the lease to the purchaser. Normally what happens is the purchaser will enter a license with the administrator so that they can access the premises whilst the company's in administration, but before they get an assignment from the landlord. The landlord can reasonably refuse to assign the lease if there's arrears of rent, so that the purchaser might need to factor that into their funding to clear some of that liability. Funding of the business, the insolvent company might have facilities with a lender that might be prepared to support the new company, but they're going to want to know in minute detail what's going on. We'd probably be having daily communications with them through the marketing and sale process. The lender might have specific goals to achieve, i.e., clearing the old company's debt on day one of the administration might be a target for them, so that they know that their exposure is only in relation to the new business. And that might mean that the purchaser has to structure the deal in a certain way, maybe apportioning consideration between fixed and floating charges in creative ways. And then the contracts, utilities. I've seen before companies similar to this sort of example might have a very important, essential IT provider that deals with their stock control system or something like that. If that company is owed a lot of money, then they may well need to be paid. It isn't right that the insolvent company pays them, because ultimately it's not the insolvent company that's getting the benefit of that, it's the new company. So again, the purchaser needs to factor that in. They need to get that sorted before they transition the business, because otherwise, without a stock control system or something like that, they're not going to be able to trade. Next slide, please, Stuart, which is the final slide. So again, that's issues in relation to the sale, but issues going forward for the purchaser. So HMRC, I've seen it in the past where certainly if it's a successor company run by the directors, I've seen HMRC ask for a deposit before they give them a VAT registration. That can obviously cause an unexpected additional cost that they might not have factored in. Ransom payments, there will be suppliers that the purchaser absolutely needs to use, and if they're owed £10,000 by the old company, they might not be too interested in trading with the new business unless some agreement is reached to clear off some of the debt, which again, that's not for the insolvent company to do, that's for the purchaser to do. If you have a seamless transfer of the business, it's typical for the insolvency practitioner to sell the stock, but subject to the retention of title claims. So for a period after completion, the purchaser is going to need to assist the insolvency practitioner in identifying any stock which is subject to valid retention of title claims. And then, the purchaser would either need to pay for that stock separately or return it to the supplier. Company records, if they're staying on the site, it might be that there's boxes of records that the purchaser wants to retain so that it can use them to continue its business, maybe employee records and things like that. Advice would need to be sought on matters like GDPR, etc. And also the insolvency practitioner would need access to the records to complete their investigations. If there's book debts, then it's common for the purchaser to assist the insolvency practitioner in collecting them, just because they might have an ongoing relationship with the customers. And then, there'd be a procedure in place for allocating the debts between old company and new company. And then lastly, personal guarantees. Some of the suppliers might demand guarantees, or at least payment on delivery, in order to keep trading with a company that unfortunately is going to be tainted with this fact that they have had a company go into administration and that they're a new company starting again. So that just another factor that any purchaser of a business is going to have to contend with. So that might be something that's called upon. So that brings me to an end. Back to Stuart to invite questions, I think.
Yeah, thanks, James. Thanks for that insight. Time-wise, it's worked out very well. Just to add, when you were talking about the prepack process and you were talking about the speed of transaction, I remember a while ago I was involved in the disposal of a business that provided software and monitoring hardware for very vulnerable people who suffered dementia and could go missing. So it's absolutely key that this software wasn't turned off and the monitoring process was transitioned as smoothly as possible because of the potential welfare concerns. And in that instance, the deal got done in 48 hours. So they can move at huge pace if there's reasons and justifications for it doing so. So thank you for the questions. We have got a couple of questions that people have asked of us, so thank you. First one we've got, we mentioned a situation where the directors are interested in acquiring the business through a prepack, but where there is another party also interested. What would you do in a situation where the directors simply didn't cooperate with the other party in terms of DD, and therefore that party couldn't formulate a reasonable offer because of that hindrance? There's statutory duties on directors to need to comply with the insolvency practitioner. But James, I'll hand that back to you if I may, and you can perhaps answer that question for us.
Yeah, so I think it just comes back to the administrator needing to be happy that he's getting the best price in the given circumstances, which is, the benchmark really. That's the criteria to hit. And if the directors are hampering another party's efforts to understand the business so that they can put in an offer, then, I can't see how that criteria can be met by the insolvency practitioner. So, the approach would be to impress on the directors the need for the insolvency practitioner to be independent. And, unfortunately, in that circumstance, if they really won't comply, then the insolvency practitioner should consider withdrawing their consent to act as administrator, I would say. I wouldn't recommend them proceed with the sale to the directors in that instance. I don't think they can play the system in that way.
Thank you. Thank you. And another question, can an unsecured creditor take steps to hinder the sale process under a prepack if they're aware of difficulty with the company? Can you elaborate whether an unsecured creditor has any rights to prevent the situation?
Yeah, well, one of the controversies about prepacks is that creditors find out once it's a done deal. So there is limited opportunity for them to scupper it. However, HMRC typically, or maybe other creditors, will have liabilities which have mounted up over a period of time. So, in the good old days, they could have issued a petition to wind up the company ultimately. And that would certainly take away the, I don't know if I use the term out of court procedure, but, this thing about filing forms rather than having a hearing. If there's a petition in place, then directors can't do that. So that would not completely scupper it. The directors can still apply to court if they want, but then the timing of completion of the sale can be much more difficult.
It's an interesting one, that one, because of course, whilst there are restrictions currently on the ability to serve petitions, it would be interesting. You would naturally, in that situation, if a winding up petition ordinarily went in, ignoring the restrictions on them currently, you would presumably go to court, and the argument as to why the winding up petition shouldn't be granted by the court would be on the basis that an administration has been recommended on the basis of the circumstances of the company and on advice from a qualified insolvency practitioner, and that in itself will generate a better return on the whole for creditors, and that would be a reason why we would petition the court to not grant the winding up order in that instance.
Yeah, and the courts can be very commercial, and they'll see, if they've got the same goal as us to get the best result for creditors, then a winding up petition rarely achieves that. I would say. The bigger concern for us sometimes is if a petition got advertised, then you're at risk of having the bank account frozen, and that's then really going to scupper your efforts to keep the business going whilst you get a deal in place. That's really where it can really fall down.
Okay. Another question, how likely do we think it is that the government will extend those temporary restrictions beyond June of this year? Interesting question. James, have you got a view on that?
Yeah, I think the interesting part of it is that the furlough, as I understand it, is being extended to September, isn't it? Which is obviously being done with the view to, allowing these businesses which have struggled to potter on until, hopefully things are booming again. But, I can't really see the logic in asking landlords in particular to hold off any longer from taking action. I mean, if you've got a business that has just not engaged with the landlord, for example, over the last year, and the landlord's going to be pretty upset at this stage, and I do feel like there is a lot of pent up enthusiasm for taking enforcement action from certain categories of creditors. So I personally think that would be a very difficult message to the landlords to tell them that that's being put off again. I can't really see the rationalisation.
Thank you. Do we anticipate much uptake in the new restructuring model that's contained in the legislation we discussed earlier? James, what's your view? I think a lot of people are sort of waiting. It's too early to tell, really. I think is the view from many. Do you have a particular view on whether that's going to leapfrog the demand for prepacks or other types of insolvency?
Yeah, as you say, it's a little bit wait and see. I mean, from my point of view, I think there's been a handful of them so far. The first one was, Virgin Airlines, I think, and, clearly a large company, and the costs were probably extraordinary. So I think the first thing to see from, my area of the market is whether we can make them cost effective to, be useful to the, the more typical clients for the likes of me, which is, owner managed businesses. So we'll see on that. The other interesting thing on that is that there was recently a challenge to one of the sort of high street CVAs. I think it was a new look one, where I shouldn't say that if I don't know what the name of the company is. I think it was that one, but if that's a healthy company, then please ignore what I said. But it was one of them. And the landlords were being treated, in their view, worse than the other branches of creditors. And I think one of the things the landlord said to the judge was, is it really within the jurisdiction of a CVA to compromise our debts, but not other debts that are also unsecured? And that really was alluding to this new restructuring plan procedure, which, has specific provisions to deal with that, because in that situation, you could treat the landlords as a different class of creditors, and the unsecured creditors that were paid in full as another class. And we've got this thing called the, cross-class cram down, which means that if certain classes agree to the plan, then you go to court, and the court can say to the landlords, well, sorry guys, I know you're being treated not so well, but in the overall context of rescuing the company, saving jobs, etc., we see the commercial rationale for doing it this way. So again, just jumping back, I think the landlords were saying surely a CVA isn't to do that, but the judge actually said, in the context of that case, it was fine. So that makes me think that the CVA as a tool is probably more likely to be flexed to deal with a lot of situations that the restructuring plan might have been used for, and the CVA might be a bit cheaper. So, it remains to be seen, but I think it will take some time, and it might be the much larger businesses with, really complex types of creditors, like bondholders and all sorts of things like that really get the value out of them.
Thank you, James. Well, that leads us to about 5 to 2. So I think both you and I have said all we wanted to. Thank you, everybody, for joining us today. I hope you found it useful. I hope you've taken something from it. Thank you very much for all of your questions. If you do have any other questions, or do want to discuss any aspects of this or insolvency generally, feel free to reach out to either James or I. Our details are on screen, and as I say, we will circulate those along with the presentation. So I think that just leaves me to say thank you, and I hope you all have a lovely rest of the day and a great bank holiday weekend. Hopefully we might get some sunshine, which will make a nice change. So thank you once again, and keep safe, and look forward to speaking to you all at some point in the not too distant future, and hopefully face to face. Bye for now.
Thanks, Stuart.